Hello friends, today we will discuss about judicial approach towards rights of LGBT in India. First of all, let us understand the meaning of LGBT. By LGBT we mean lesbian, gay, bisexual and transgenders. So, in today's discussion, we will have a basic idea and understanding of the rights of LGBT in India and what is the stand, what is the approach of Indian judiciary. So, let us start our discussion on judicial approach towards rights of LGBT. Designed on the foundations of this edifice of human rights, the Constitution of India also recognizes equality before law to all individuals without any discrimination on the grounds of race, religion, caste, place of birth or sex, etc. The rich language of the preamble and thereafter the content of the different articles under part 3 and part 4 certainly present an ideal image of a society treating all equal. However, the language of the Constitution has to be construed in context of socio-economic and political spectrum prevailing at the time of interpretation. The duty of the interpretation of the provisions is bestowed upon the Supreme Court of India. Therefore, in order to make a constitution organic and living entity, the Supreme Court infuses new spirit and dynamism through its tools of interpretation. The script of the Constitution certainly incorporates the dictum includes all and exclude none. The language of the preamble envisioning equality of status and opportunity, liberty of thought, speech and expression, dignity of individual and furthermore, various rights recognized in part 3 certainly treats all persons equal in terms of sexuality. Section 377 of Indian Penal Code criminalizing consensual homosexuality is a pre-constitutional law. Friends, its sustainability in post-constitutional era by virtue of the saving clause of Article 372 of Constitution resulted into its conflict with the constitutional spirit of the rule of law. Law itself deprived of all LGBTs and HIV infected people of their right to health, medical assistance, equal opportunities and marginalize them. Narrow interpretation of right to life and personal liberty, right to privacy and right to live with dignity resulting into the sufferings of the individuals of LGBTs and presented a serious challenge before the administration of justice. With the passage of time, the Supreme Court of India changed its stance from narrow to liberal construction and addressed the hardships at the right time. In view of this background, this discussion aims at unfolding layers of principles expounded and elaborated by the Constitutional Bench of the Supreme Court of India in Navtej Singh Johar versus Union of India, All India Reporter 2018, Supreme Court 4321. This judgment, being a magnum opus, infused fresh insights by recognizing individuality within the domain of right to life and dignity guaranteed under Article 21 of the Constitution. And it reversed its approach, overruled its own judgment given in the matter of Suresh Kumar Kaushal. the court recognized that individuality is an innate and natural aspect of one's life and personality. The society should have minimal intervention in one's individualistic affairs, intimate choices and sexual orientation. Addressing the challenges of constant persecution through unequal treatment, disparities, oppressions, rule of law and marginalization, the Supreme Court of India attempted to bring LGBTs into mainstream by undoing the rhetoric. Friends, this judgment is not less than a bill of rights for individuals beyond gender binaries to restrain the brutal majoritarian forces. It marks the dawn of a new era, recognizing the rights of the lesbian, gay, bisexual, transgender to equal opportunities as the part of mainstream and to live in harmony with others and assure dignity. The court in this case took note of the following several instances of persecution and expulsion culminating into feel of dejection, disappointment. The scope of this discussion in this presentation has been confined to jurisprudential aspects of the issue, covering the kinds of morality involved in this issue, distinction between constitutional and social morality, theories of rights, multiple aspects of privacy, obligations of state to decriminalize and be inclusive. By virtue of this decriminalization, the rights of LGBT have been recognized within the framework of the Constitution. Let us have a look at the national perspectives on sexual orientation. An egalitarian society accommodates diversity of languages, cultures, ideologies, whether liberal and conservative as well. Social realities under dejection are more aggravated in the form of verbal harassment, familial fear, restricted access to public spaces and the lack of safe spaces for consummation, resulting into the denial of their self and obliterating the identities as well. Now, let us have some ideas of privacy and autonomy. Friends, privacy is a concomitant of the right of the individual to exercise control over his or her personality. It finds an origin in the notion that there are certain rights which are natural, inherent in human being. The human element in life is impossible to conceive without the existence of natural rights. Rights of LGBT are not so-called rights, but are real rights founded on sound constitutional ethos. These rights dwell in privacy and dignity. Sexual orientation is an essential component of identity. The Supreme Court of India underscored that right to privacy under Indian Constitution is quite pervasive, covering spatial privacy, decisional privacy and the privacy of choice. Emanating from the inalienable right to privacy, the right to sexual privacy must be granted the sanctity of a natural right and be protected under the Constitution as fundamental to liberty and as a soulmate of dignity. Friends, now we will discuss how human dignity is considered as relevant in this scenario. Human dignity is inseparable constituent of personality. Dignity, though it is very difficult to define in the exact sense, but it has been observed by the Supreme Court as indispensable part of right to life. The Supreme Court of India in K.S. Puttaswamy and another versus Union of India and others, 2018, 5 Supreme Court cases 1 prefer to deem it as intrinsic value of every human and the meaningful existence. It further elaborated the meaning of dignity in Common Cause versus Union of India and another, All India Reporter, 2018, Supreme Court 1665, to cover liberty to self-determine, self-expression, autonomy, bodily integrity, one's sexual inclinations. The interrelationship among above all establishes that a person, if becomes homosexual or any of LGBTs, that person does not cease to be an individual. He is still a person. One's individuality does not perish. Criminalization of one's sexual orientation by the society affect one's mental status as well as one's family, profession, social and educational life. Absence of dignity for a few, even in minority, may certainly sooner or later create a chaos and disorder in a society. It may backfire by dividing the society into haves and have-nots, ultimately threat to ideal of fraternity. Civilized societies must inevitably ensure one's dignity by providing them freedom to exercise their choices within reasonable restraints. Discrimination on the ground of sexual orientation is dual opposite of dignity and self-respect of the individual. Curtailment of that expression and the ultimate action emanating therefrom on the conceptual structuralism of obeisance to the social will may destroy the individualistic entity and dignity of a person. The social and moral values have their space provided consonant with the constitutional ethos. So, I hope you must have understood that social and moral values must be in consonance with the constitutional values. Now, the decriminalization of section 377 by the Supreme Court and what was the jurisprudential ethos. Let us have a look at it. Criminalization of homosexuality has its roots in British history. Revisiting historical approaches towards Greco-Roman times, emergence of Christianity and medieval times can help us to understand the mindset behind criminalization of homosexuality. Much clarity can be gained from position of Catholic Church. Christianity opposed homosexuality being unnatural. Theologian Thomas Aquinas observed that unnatural sexual practice of homosexuality is having its root causes in the corruption of the soul and distortion of right reason. He opined that unisexual lust is unnatural crime. Aquinas, as consequentialist, examines the validity of sexual intercourse on the basis of outcome, results. He says procreation was the ultimate purpose of sexual intercourse. Same-sex relations not resulting into procreation were addressed by him contrary to nature. Usually, vaginal intercourse is potentially procreative sex act. Thus, oral or anal mode of sex between their two or homosexual were called against nature by Thomas Aquinas. The social perception arose from the dominance of church that all methods of sexual processes by the use of the organs other than natural, penis to vagina, are unnatural. Now, if one evaluates the legitimacy of sexual acts on the basis of consequence of procreation, sexual intimacy between same sexes is forbidden. However, if the purpose is not to procreate then, but to exercise personal choice, loving and being loved, bonding and inclination towards the same sex, these should not be treated either harmful or immoral. These feelings are also natural. And continuation of homosexuality as crime in 21st century demanded fresh insights. An act to be punishable needs to be tested on the yardstick of harm principle. Relying on Mill, the Supreme Court held that the state is authorized to intervene in private life provided harm is caused to others. Power of the civilized state can be used to prevent one from causing harm to others. So, if Mill's theory is applied in context of homosexuality, the Supreme Court observed that it is disgust, not the harm caused to others. It does not authorize one to go on or dictate others. From Bentham's point of view, if homosexuality is viewed outside the realms of morality and religion, its neutral behavior which gives the participants pleasure and does not cause pain to anyone else. Such acts cannot constitute offense and no merit in punishing at all. He laid down a triple layers test to examine validity of sodomy laws. 1. Any direct harm to any other person. Number 2. Any harm to the stability and security of the society. Number 3. Any danger to society. And if we apply these tests on the acts of homosexuality, the answer to above questions are negative. No harm is caused by the act of sodomy. It just produces pleasure, and pleasure is by their perverted taste. Both the individuals are willing. They neither harm any individual nor disturb the peace of the society. The ultimate purpose of law is to augment the total happiness of the community, and excluding anyone from happiness by punishing through law is itself an evil. To sum up the issue of criminalization, it is apt to quote Aristotle. To quote, justice in relation to the person is defined in two ways. For it is defined either in relation to the community or one of its member, what one should or should not do. Accordingly, it is possible to perform just and unjust act in two ways, either towards a defined individual or towards the community, unquote. Therefore, as stated earlier, the acts of individual are not causing any harm to the society, and these acts are based on their natural instincts. Unjust is caused when any harm is done and person causing harm is spared. In such acts of purely personal nature, where our persons have their consent, the society should respect privacy and give due space to the individuals. Right to privacy has been recognized in post-World War regime, while criminalization of homosexuality is injected in colonies during British rule. It is part and parcel of right to life. Even in the matter of Justice K. S. Puttaswamy, the Supreme Court recognized privacy as an inalienable part of right to life. Sexual urge and consent-based sexual relations, even between the same sex, are absolutely individualistic phenomenon falling within the purview of right to privacy. The expression order of nature used under section 377 is used and applied by the social and religious analogy. Therefore, the conflict between privacy and socio-theological analogies will certainly be resolved in the modern world in the favor of former, as endorsed by Nietzsche. To extend protection to natural inclination to quote, "Same-sex love is not a mockery of nature, but rather nature at play." Finding no reason to sustain criminalization of homosexuality, the Supreme Court resolved in favor of Article 21 to give paramount importance to dignity of life by restoring privacy and autonomy. Now, let us have look at the approach of the Supreme Court to distinguish constitutional morality versus social morality. Friends, the judgment of the Supreme Court in Navtej Singh's matter will be remembered by generations to come for its meticulous contribution in distinguishing constitutional morality from social morality. The learned advocate for the petitioner, Arvind P. Datar, articulated that the Supreme Court in imputed judgment delivered in Suresh Koshal was guided by social morality, leading on majoritarian perception. Taking cues from the observations of Aristotle, Bentham, Mill, and many other philosophers, the Supreme Court resolved the dilemma between the constitutional morality and social morality. It observed that in the matters concerning privacy, dignity, anti-discrimination approaches against marginalization and deprivation of basic human rights of sexual minority, social morality has to yield to constitutional morality. The constitutional governance in India kept certain rights of individuals and discrete and insular minorities beyond the reach of majoritarian governments. These rights should be equally available to all to avoid rhetoric. Rights of an individual ought not to be persecuted by dictates or social prejudices in a democratic framework. Social transformation envisioned by the framers of the Constitution can become a reality only if all the cultural, linguistic, religious, sex minorities have constitutional safeguard against the tyranny of the majority and the governance is inclusive. The Supreme Court removed the fallacies arising out of the unclear difference between social morality and constitutional morality. Social morality is basically contextualized in the past and existing factors, while constitutional morality is constituted not only in the past, present, but futuristic vision also. Societal values and moral ideas are always dynamic in nature. It certainly laid a dictum that in case of friction between constitutional morality and social morality, constitutional morality will prevail. Since social morality by nature is scattered due to variable social, economic and political forces at its foundation. On the other hand, constitutional morality is clearly spelled out and overshadows social morality, resulting into withering away the differences. Gradually, it becomes part and parcel of the life of stakeholders, provided the constitutional morality is resilient and can mitigate the friction between organic and inorganic forces. So, rapid transformation demands timely customization of laws and adaptation by the institutions of justice. In such a situation, the identification of gap between kinds of morality is very significant to ensure sync in society, morality, law and justice. Administration of justice should respond to the needs of social values, goals and policies to fill up the vacuum by interpreting law in compatible way. The beauty of Indian Constitution is that its spirit envisions to include all, exclude none. It is adequately receptive and adaptable to organic socio-political forces. Besides, it gives due significance to minorities and accommodates pluralism. The foundational principles of Indian Constitution swear the virus of Section 377 to extend inalienable rights beyond gender binaries. Furthermore, the societal notions of heteronormativity should also not be permitted to stand in the way of enjoying the fundamental freedoms by the stakeholders. By discontinuing the perpetuation of injustices and opprobrium of sexual minorities, the Supreme Court realized the dream of transitional justice by drawing the curtain on the past. So, let's go for conclusion. The upshot of aforesaid discussion is that the Supreme Court, being the crusader, delivered the judgment which cannot be considered less than a Bill of Rights of LGBT. Understanding the limitations of other two organs of the government and giving them due respect, it gave paramount importance to constitutional morality. It acknowledged the prolific observation of Lord Neuberger, lightening the path on the way of its adventure to recognize the rights of LGBT. To quote, "We must always remember that Parliament has democratic legitimacy, but that has disadvantages as well as advantages. The need to offer oneself for re-election sometimes make it hard to make unpopular but correct decisions. At times, it can be an advantage to have an independent body of people who do not have to worry about short-term popularity." The respondents and interveners contended that revisiting this matter shall present court as a counter-majoritarian institution. Rejecting this contention, the court observed that being a watchdog of constitutional morality, it cannot turn a blind eye towards its responsibility of protecting constitutional entrenched rights regardless of what the majority believe. So, resisting the temptation to move on the linear tracks, appeasing majority, unlike other two organs, the Supreme Court showed its courage and untiring commitment to restore faith of the stakeholders in the Constitution. It decoded the charts, script of the Constitution and legal instruments, and paused on the language to continue its movement from Fox Palace jurisprudence to toy jurisprudence. Finally, it is submitted that in contemporary civilized society, looking at achieve Agenda for Sustainable Development 2030 based on inclusive participation and governance, the Supreme Court has performed its constitutional obligation to realize the rights progressively. Going beyond the gender binaries, it unfolded a new chapter of constitutional governance to apply balm on the sufferings and pain of millions for sustaining transformative constitutionalism. Above contribution was confined to the judicial approach beyond gender binaries in Indian context. Jurisprudential analysis of various foundational concepts directly and indirectly related with the theme makes it clear that no discrimination can be made on the ground of sexual orientation and gender identities. The judgment is revolutionary in context of inclusive society and constitutional governance. The judiciary has really done a splendid job worth impact on the lives of millions. Now, the stakeholders have to be sensitized by all the citizens to translate the theoretical dictum into reality and making part of public life. Without the awareness of stakeholders, the society may or may not afford their recognition. To quote Baba Saheb Dr. B.R. Ambedkar, the assertion by the individual of his own opinion and beliefs, his own independence and interest over and against group standards, group authority and group interest is the beginning of all reform. but whether the reform will continue, it depends upon what scope the group affords for such individual assertion." Unquote. I hope this discussion might have helped you to understand the contribution of the Supreme Court in recognizing the rights of lesbian, gay, bisexual, transgenders in India.